Now sitting, God save the United States and this honorable court. Please be seated. First case on the calendar, that of Vincent Huff versus the state of Texas, is now in session.
Is the petitioner ready?
Yes.
Stand.
Yes. I am Logan Dowell.
Sit down. Is the respondent ready?
Yes, Your Honor.
Petitioner, you may proceed.
I am Logan Dowell, and I am representing Vincent on the first point of error of sentencing, and this is my co-counsel, Brady Williamson, who is representing Vincent on his Miranda rights. Defendant Vincent Huff was charged and convicted of first-degree murder of his grandfather, Cedric Huff, by the 3rd District Court of the state of Texas. Mr. Huff is found guilty of first-degree murder and is given life without parole. Vincent Huff appeals his punishment of life in prison on 2 points of error. 1, regarding his rights under Miller v. Alabama and its farther advancement of Montgomery v. Louisiana, if life without parole for a child is justifiable, and 2, regarding the legality and acceptance of Vincent Huff's confession. The appellate gets his case retried and is still found ineligible for parole. We come to the court today with the appellate still being denied his constitutional right given to him by the President of age and other mitigating factors. Would you like a statement of the facts?
Yes, counsel.
The appellate's grandfather discovered him and his girlfriend in his room. The appellate gets into an argument with his grandpa. After the fact, it escalates too far and the appellate impulsively stabs him. The appellate attempted to give his grandpa CPR. However, even after his intense efforts, he was unsuccessful. Afterwards, a neighbor had reported to the police that there were suspicious activities at Huff's house. The police caught up to Vincent at a nearby gas station, where he is questioned. The appellate, before he received his Miranda rights, where he admits to killing his grandpa. He is put on trial and given life without parole for first-degree murder under Section 19(2) of the Texas Criminal Code. And now I'm going to introduce LWOP. The definition of life without parole has changed over time, especially since the ruling of Roper v. Simmons. Using Roper v. Simmons, the court overturned Christopher Simmons' death penalty based on a shift in public opinion. Opinion has shifted to say that the death penalty is cruel to underage criminals. The 8th Amendment requires the government be respectful of the dignity of all citizens. If a juvenile typically does not consider the consequence of the action and are more likely to engage in risky behavior, then the same irrational mind is not going to perceive the deterrence of the death penalty as a limiter of their behavior. If this punishment does not deter the crime, then an alternative punishment should be found. The same is true for life without parole. Quoted in Roper, in any capital case, a defendant has a wide latitude to raise a mitigating factors argument.
Counsel, you mentioned Roper v. Simmons, which is regarding a death sentence. However, in this case, we're considering a life without parole sentence, which is arguably much lighter of a sentence. How can we apply the ruling in Roper to this case?
As I previously stated, Roper caused a change in public opinion. Roper was in 2005, and then as we see, I'm going to touch on this later. In 2010, Graham v. Florida advances the right for life without parole to all non-homicide juvenile cases, and then Miller later advances that to all cases that deal with juveniles. And then Montgomery goes a step farther and makes those cases apply retroactively. Does that answer your question?
Yes, you may proceed.
Okay. Character or record and any of the circumstances of the offense that the defendant prefers as a basis for a sentencing less than death. Walker v. Ohio, Eddings v. Oklahoma, Johnson v. Texas, and Furman v. Georgia. Concerning sentencers' consideration of aggravating and mitigating factors, there are a number of crimes that beyond question are served in absolute term, yet the death penalty may not be imposed for their commission. Coker v. Georgia. This developed into underage defendants having a wider latitude to raise mitigating factors. Life without parole cases should have the same latitude. The Eighth Amendment's usage in cases has changed over time, but today, the Eighth Amendment protects against life without parole. Graham v. Florida advances the right to all non-homicidal cases, with Miller advancing the right to all.
Counsel, however, Miller does not bar life without parole. It only states that the court must consider mitigating circumstances as well as consider an alternate penalty. So if your argument is that Miller bans life without parole, then I believe that is incorrect.
Miller, he said, well, they didn't consider the mitigating factors in this case, as we see, because Montgomery also requires the court to make a determination if they are to put a juvenile or give them life without parole. And in this case, there was no determination made. And
so could you clarify determination?
It's the judge has to write a written report, or they have to publicly give a hearing of why they gave him life without parole.
Okay, you may proceed.
The Texas court, Miller applies retroactively to past cases, and they must be given parole. The Texas Appeals Court erred in denying the consideration of Vincent's mitigating factors in this case. These factors are directly related to Vincent for the following reasons. Mitigating factors can deal with background, age, and emotion, which all affect his culpability. The court erred in not considering the harsh background that Vincent had as a child. Based on the fact that Vincent lives only with his grandparents, this reflects he did not have the proper parental uprising due to their absence in his life. A very similar case to this would be Eddings v. Oklahoma. As the case explains, a child of age 16, Eddings, ran away from his parents and stole his dad's shotgun. He ended up killing a police officer with his shotgun. The court ruled that the child could not be given the death penalty as the court did not consider the mitigating factors such as harsh background. The court remanded and reversed the findings of the case. This shows that not considering Vincent's background is a factor that can reverse the case. Vincent was also more remorseful than Eddings as he gave his grandpa CPR when Eddings shot the police officer and ran away from the crime. Eddings' crime is more egregious than Huff's, yet they got the same sentence.
Counsel, you argue that Eddings' crime was more egregious. However, Huff did shoot his own family member and hide his body, so which part of it is more egregious?
Huff attempted to give his grandpa CPR, whereas Eddings shot the police officer and ran away in his car. Huff also, we think his action was impulsive as it was based off emotion. This does not deter what he did, but it can explain why he did the crime, and it was not planned, which makes it not egregious.
So, counsel, could this not also be applied to Eddings, where you could say that he impulsively shot the police officer?
No, because the police officer just said, "What are you doing?" and he pulled out a shotgun and shot him, which he did it for no reason. When in Vincent's case, he got in a heated argument with his grandpa, and he ended up shooting him.
You mentioned that he did it for no reason. Would that not imply that it was impulsive?
I wouldn't say so, because he didn't know what he was doing, and he just shot the police officer.
Okay, proceed.
Court also did not rule on the fact Vincent has no prior criminal record, which shows that his actions is less heinous than the state makes him out to be. The court also did not consider his emotional state as an explanation of his behavior. Vincent killed his grandpa.
Also, could you discuss how we can determine where we can draw the line for the proportionality standard and determine what is the appropriate punishment for Huff in his crime?
So juveniles, as I previously stated, they do not deter death penalty or life without parole as a limiter of their crime. So we gotta find a crime that punishes them, but is fair to them, and they can the crime changes them in a sense, and makes them a better person later in their life.
Thank you, counsel.
Vincent killed his grandpa because he was frustrated, even attempting to give his grandpa CPR. This does not justify his crime, but can illustrate that the crime was not egregious, nor is Huff incorrigible. This shows that the court failed to consider these factors and misjudged Vincent for the crime. By refusing to admit these mitigating factors, Vincent Huff could not receive a fair trial, and this error becomes a reversible error. Another key issue that the Texas Court of Appeals failed to consider is Vincent's age in this case. Being a child, he should be ruled differently than an adult, as previously defined according to Roper v. Simmons. The difference between juvenile and adult offenders are too marked and well understood to risk allowing a youthful person to receive the death penalty, despite insignificant culpability.
Counsel, how would it be different if Huff was 17, let's say, rather than at his age at 15? Would it be any different? Like, should we treat him differently from a juvenile at 15 or like as an adult offender at 18?
We think that below 18 is subjective. And since like Vincent, he can't even like drive a car or vote legally, so how do we expect to rule them the same under the law? And if he was 17, I think it would be the same case because he still can't vote legally, he can't have alcohol, there's so many limiters of his behavior.
Counsel, Miller and Montgomery sought to ensure that life without parole for juvenile offenders was rare but not impossible. So for which sort of crime should life without parole be considered?
And very like heinous cases of murder, like in school shooting cases where the shooter goes and shoots up the school, and other cases like that that are like very heinous crimes that are egregious. Vincent's crime is also not very rare, as murder happens all the time, and it's not like egregious.
Okay.
And the difference between juvenile and adult offenders are too marked and well understood to risk allowing a youthful person to receive the death penalty, despite insignificant culpability. An unaccepted likelihood exists that the brutality or cold-blooded nature of any particular crime would overpower mitigating arguments based on youth as a matter of course, even where the juvenile offender's objective immunity, vulnerability, and lack of true depravity should require a sentence less severe than death. The crime he committed was judged to be egregious. An egregious crime is defined as Lockett, as a rare capital case, but Vincent's murder is not rare, nor is he incorrigible, as the crime is impulsive based on immaturity. Also, the court erred by only looking at the crime itself and not the offender, which the court has proven holds weight, especially in Roper. The government requirement is to treat each person with dignity, which means to recognize the humanity of each individual, then match the accusation to a crime, which is also outlined in Roper. His act was impulsive as he got frustrated mid-argument with his grandpa and ended up stabbing him. This illustrates the fact that the court did not consider his emotional state another mitigating factor. And I would like to move on to why the 14th Amendment was violated in this case.
Counsel, just to clarify, Cedric got into an argument with his grandfather and then stabbed him after, not during the argument, correct?
It escalated to a point where he got angry mid-argument and stabbed his grandpa. That's what happened.
I do not believe that is correct. Okay. I agree. You're talking about the second argument?
Okay.
Yes.
By denying the mitigating factors, the court denied Vincent's right under the 14th Amendment. We understand that Miller did not require a determination of permanent rights for past cases, but its expanding case, Montgomery, requires that the court has to make a determination that an offender is permanently incorrigible in order to give LWOP. The court must have a record of this if it violates the Constitution as mentioned. The appeal court failed to make a determination in Vincent's case, thus making it unconstitutional to give him life without parole. There are many ways to make a determinations that are not used. Common ones mentioned are providing a hearing, a judge's written opinion, or writing briefs or finding that Vincent is permanently incorrigible. This never happened in Vincent's case, as no determination was made. As Montgomery states, failure to apply a subsidiary rule like Miller v. Alabama always results in a violation of constitutional rights.
Counsel, in Miller, it stated that only that a sentencer must follow a certain process considering an offender's youth and attendant characteristics before imposing, not that the court must find a permanent finding of permanent incorrigibility.
I'm not arguing that Miller said that. I'm arguing its later advancement. Montgomery said they must make a finding of determination if they give a defender life without parole. This supports that Vincent's rights were violated, making the error reversible. If the court finds mitigating factors as an error, then Vincent's sentencing is still out of proportion when compared to similar cases. In the case Eddings v. Virginia, Eddings was charged with capital murder, armed robbery, and abduction, but was protected from the death penalty because of mitigating factors. from his horrific crime. Vincent's crime was way less damaging than Eckes, and he can still not get parole. This shows that the lower court did not rule the case in the correct manner. As mentioned previously, Eddings and Vincent got the same sentence, when one was murdered with little to no reason, and one had an impulsive act. I would just like to summarize my main points. First of all, Roper kind of established the precedent of the shift in public opinion, and later advancements of Montgomery, Graham versus Florida, Miller versus Alabama, and Montgomery used what was mentioned in Roper to kind of create what is now like why juveniles are protected from life without parole. And the court, our main point of argument is the court failed to make a determination which is required by Montgomery. And since there was and under the criminal law, it also requires them to make a determination in Texas. I would like to pass the rest of my time to my co-counsel, Brady Williamson.
Good morning. My name is Brady, and I will be representing the appellant Vincent Huff on the second point of error regarding the acceptance of his admission of guilt. The court erred in accepting the confessional statements made by Vincent Huff due to the fact that he was not Mirandized. On to my first point. The state infringed upon Mr. Huff's Sixth Amendment right as he was never Mirandized, leading to the improper acceptance of his admission of guilt. The three cases that directly apply to this case are Berkemer v. McCarty, Stansberry v. California, and Rososco v. Texas, as they all exhibit that defendants who are improperly Mirandized or not Mirandized at all have had their rights infringed upon. Berkemer is the umbrella case, as stated in the conclusions of Berkemer. Once a defendant is detained or taken into custody, they must be made aware of their Miranda rights before any questioning takes place. This is done to protect the rights of the accused. Being in custody, according to Thompson v. Cahane, means that whether a reasonable person would feel free to leave the scene. And as Vincent was being searched, he was clearly not allowed to leave.
Counsel, since Vincent Huff did lie to the officers about his name, would that not imply that he felt freedom enough to lie and freedom enough to leave?
No, as whenever he lied, the officer then began to search him. And as somebody who had the police going through their pockets, I would certainly not feel free to leave if I was being searched by the police.
Counsel, wouldn't a reasonable person be able to comprehend that if they were being patted down by police for further evidence that they are currently under investigation and that any statements that they make could be used against them?
No, as a reasonable person is, to the court, a reasonable person would be considered an adult, while in this case Vincent is still a minor and should be treated differently, as my co-counsel Logan previously had stated. Vincent Huff was considered to be in custody once he had made false testimony to the police and was being searched. Like I said earlier, a reasonable person who had the police going through their pockets would not feel free to leave.
Counsel, you just claimed that because of Huff's age, he would not be considered a reasonable person, and now you refer to him as a reasonable person. Could you please clarify which definition you're going with?
The definition made by Thompson v. Kane. According to Stansberry, any person should be made aware of their Miranda rights, regardless of the officer's subjective view. The Supreme Court's decision stated that the officer should have given Vincent Huff his Miranda warnings long before he began to ask Vincent Huff any questions, as it would violate his Sixth Amendment rights, allowing for a reversible error. Furthermore, Rososco v. Texas reinforces this point, as in that ruling, the Supreme Court ruled that even though the defendant was not in a traditional police setting, as a police station or police car, his Miranda rights still should have been applied before any questioning took place. In this case, Rososco was questioned at his house and subsequently was not Mirandized, which later the Supreme Court deemed to be illegal. This is very similar to Huff's case, as he was being interrogated outside of a police setting, meaning that the precedent made by Rososco directly applies to this case, as Mr. Huff should have been Mirandized due to the fact that he was not free to leave.
Counsel, I'm sorry, could you please define Mirandized?
Mirandized, the police officer giving him his Miranda rights, like telling him that anything he can say can and will be used against him. In conclusion, the court erred in accepting the admission of guilt due to the fact that he had not been Mirandized. This precedent set by Berkemer, Stansberry, and Orozco are all applicable to this scenario, as their rulings given by the Supreme Court all affect this case. These cases demonstrate that the admission was illegally accepted, as according to Berkemer, Vincent should have been, again, Mirandized once he was not free to leave, while the other two cases, Stansberry and Orozco, state that before questioning began, Vincent should have been immediately Mirandized, regardless of location. Vincent had his rights infringed upon by allowing this admission to be used in trial, as it was an illegal admission. At the bare minimum, this is grounds to reverse and remand this case. Even if the court disagrees with Mr. Huff on the previous points of issue, the court should consider this point. After the decision made by the court's ruling related to Miller versus Alabama, the sentencing imposed upon Vincent Huff at his resentencing trial is illegal, as he received an illegal sentence after his appeal had failed. This is due to the change in Texas Penal Code, Section 1231, which states, an individual adjudged guilty of a capital felony in a case in which the state does not seek the death penalty should be punished by imprisonment in the Texas Department of Criminal Justice for 1, life if the individual committed the offense when younger than 18 years old, as Vincent did, or 2, life without parole if the individual committed the offense when 18 years or older. This, however, does not give the opportunity for a youth offender to receive the punishment of life without parole. The Texas law states that only offenders who are older than 18 years old may be subjected to a punishment of life without parole. The outcome of the resentencing can affirm, modify, or overturn an original sentence, creating a new judicial determination, meaning whenever Huff was re-given his punishment of life without parole, it was an illegal punishment at the time, due to the change in Texas Penal Code, Section 1231. What matters in this court today is, again, point 1, in that a minor is legally only allowed to be sentenced to life with the possibility of parole after 40 years. This would have resulted in a direct violation of Texas law and rendered this verdict illegal, meaning that, at a minimum, a retrial is mandatory per Texas Code of Procedure Chapter 37-7.
Counsel, although this might be banned with Texas law, it is still allowed within Supreme Court and federal law. So which law and which ruling should we apply in this case?
We should apply the Texas law, as Vincent Huff was being retried. His original sentence occurred in Texas, and his resentencing occurred in Texas, meaning that the Texas Criminal Code of Procedure is what law they should follow. As my co-counsel Logan mentioned earlier, Vincent Huff's committing the murder violated the Texas Code of Criminal Procedure. Your Honor, Vincent Huff hopes that you will decide that he was wrongfully given the sentence of life without parole without taking into account his mitigating factors, as well as the illegal admission of guilt, as well as the illegal verdict under Texas law. We ask that the court redress these errors of law as they are reversible. We pray that the court reverses and remands the case based on these reversible errors of law. Thank you.
Thank you. Appellee, are you ready?
Yes, Your Honor.
You may proceed.
Good morning, Your Honorable Chief Justice and Associate Justices. My name is Casey P. Scores, and I represent the appellee on Issue 1. This is my co-counsel, Elena Prager, and she will represent the appellee on Issue 2. However, before I dive into my argument, I would like to address some of the statements made by my opposing counsel. First, they made a very clear statement that permanent incorrigibility must have a factual finding associated with it. However, neither Miller nor Montgomery requires this. They're highly suggested, but another important thing that I heavily touch on in my argument is Miller and Montgomery base themselves around mandatory life without parole sentences. Hence, a permanent finding of incorrigibility given to when applied to someone who was given a mandatory sentence of life without parole because of their crime is very different than someone who was given life without parole because in a discretionary sentence. Also, my opposing counsel brings up mitigating factors quite a bit. And I agree, mitigating factors are incredibly important, and we see this in dozens of precedent cases provided to us. However, when a constitutional defect arises with mitigating factors, it's because those mitigating factors were obscured from the court's purview. In our case today, the only mitigating factor that we have that is factually provided to us is his age. And because we are a court of facts, we cannot go off of the assumption that Huff had a hard home life, or that his parents were not around, and that emotionally hurt him. In Eddings v. Oklahoma, yes, that is a mitigating factor to that case because that information is provided. I'd also like to address, there was a bit of confusion on whether Vincent Huff shot or stabbed his grandfather. In our case facts, Vincent Huff did stab his grandfather 8 times. And we were also not given the 14th Amendment or any penal codes or any other constitutional articles, and thus cannot apply them to any of our arguments in this court today, Your Honor. I also wish to draw this court's attention to issue 2. My opposing counsel says that Vincent Huff needed to be Mirandized before he was asked any questions. However, Miranda clearly sets a precedent that if an officer needs to ask a discovery-based question for the safety of the officers and others around, they can. And that is what the question asked to Vincent Huff was. Is there a knife on you? Is this the knife you did it with? I agree, the wording could be incriminating, but the heart of it was, is there a weapon that could harm me or my other police officer? And he was also never officially taken into custody. I wish to talk about Stansberry v. California, which establishes that Miranda warnings are only necessary in the admissibility of statements made in the case of a custodial interrogation.
Counsel, could you differentiate between a custodial interrogation and a questioning that aims at finding more facts?
Yes, of course I can, Your Honor. So, a custodial interrogation is when there is a significant restraint on the person's freedom and they are unable to leave. This often happens in police-dominated spaces, like police stations, as we see in Yarborough v. Alvarado. However, a non-custodial interrogation is something that happens outside of a police-dominated station where a reasonable person would feel free to leave. And a reasonable person put into the circumstance of being questioned at a gas station would feel free to leave. They would also feel free not to lie to the police officers about their names.
Thank you, counsel.
If there are no further questions on that, I will begin my argument.
Counsel, you emphasized location, that custody occurs in a location that is predominantly police-dominated. However, in Orozco, Texas, it was specifically stated that Miranda warnings are necessary whenever a person is in custody, regardless of location.
Yes, and I completely understand that. I was really giving the definition for a custodial interrogation, and Miranda provides us with the idea that most custodial interrogations do in fact take place in a police-dominated space. However, the difference between Orozco and our case today is the fact that he was in a full-fledged interrogation. Vincent Huff was asked a discovery-based question for the officer's safety. Issue 1 is whether or not the trial court abused its discretion by imposing a sentence of life without parole without finding that Huff is permanently incorrigible. I'd like to start my argument today by providing this court with the very reason we are here. In June of 2012, the Supreme Court issued a ruling on the landmark case of Miller v. Alabama, a case that bases itself on the unconstitutionality of mandatory life without parole sentences for juveniles under the age of 18. Miller itself does not require a retroactive approach. However, with the establishment of Montgomery in 2016, Miller was given this retroactive effect. That brings Vincent Huff's case to this court today. With this retroactive power appointed to Miller, also came insolent offenders with confidence to bring appeals that base themselves not on precedent, but instead grasp at unconstitutional straws. As I stated previously, Miller bases itself on how mandatory life without parole sentences violate the 8th Amendment rights afforded to individuals. These rights, as defined by the Court of Atkin v. Virginia, 2002, are excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The question that then emerges is what makes a punishment cruel and unusual? The Atkins Court, along with the courts of Miller v. Alabama and Graham v. Florida, 2010, laid out a way to determine the answer to this question. The answer is proportionality. The Atkins Court introduces this idea by laying out that a punishment is cruel and unusual if, and only if, the sanctions of the punishment are excessive in nature in comparison to the crime. The court then makes the clear and definitive statement that it is a precept of justice that punishment for crime should be graduated and proportioned to the offense. The Graham Court then provides insight into how these standards actually apply to determining proportionality, as the 8th Amendment contains a narrow proportionality principle that does not require strict proportionality between crime and sentence, but rather forbids only only in extreme sentences that are grossly disproportionate to the crime. So the question I present to the court today is a discretionary sentence of life without parole given to a violent murderer grossly disproportionate? According to the courts, no, it's not. The only way for there to be disproportion in our case today would be if there was a mandatory life without parole sentence.
Counsel, you frame Huff as a violent murderer. However, in another light, would he not be considered a young, immature teen who committed an offense, but should be given room for improvement later in life?
Your Honor, I think that's a very hard and subjective question, and given that this is a legal court, it is not up to me to decide whether philosophically we should allow him to go and rehabilitate himself. However, I can answer that rehabilitation can and does happen in prison. In fact, that's why Miller and Alabama were even presented to the Supreme Court, because Evan Miller rehabilitated himself and was able to show that his mandatory life without parole sentencing was not necessary. However, Vincent Huff has not provided us with any form of rehabilitation.
Could his act of CPR upon his grandfather not be considered an act of rehabilitation?
No, Your Honor, because simply put, it's too little too late. He stabbed his grandfather 8 times. That's not an accident. That's not impulsive. That is anger and that is violence. Violence that ended someone's life.
Counsel, how can we decide whether Appellant Huff was one of the rarest of juvenile offensive for the cases according to Montgomery?
So, Your Honor, I will talk about almost a finding of permanent incorrigibility that is found, because we as the state do believe there was a finding of it that came with the sentence of life without parole and first-degree murder instead of the sentence of manslaughter and the lesser punishment that will in fact come with that. We use Johnson v. Texas to back that up. Would you like me to skip ahead to that part of my argument and then circle back?
No, Counsel, you can continue with your argument.
Which there wasn't. Your Honor, in fact, the jury was instructed on manslaughter. I'd like to state that the point of my argument today is to set an overruling precedent that maintains Montgomery's retroactive approach on Miller, but solely allows for life without parole cases with mandatory sentencing and those with the severest of constitutional defects to bring their cases to the court today. The final point I wish to draw this court's attention to is the separation of a cruel and unusual punishment and an acceptable punishment. It is not one of age, but how the severity of the punishment lines up with the crime. I feel I need to emphasize this because clearly Vincent Huff seems to believe that because he is 15, he should be absolved of his violent crimes. To disprove this argument, I draw this court's attention to the precedent case of Johnson v. Texas, 1993, where the court states, if a juror believed that Petitioner's actions were merely a result of his youth, that same juror would naturally believe that Petitioner would cease to behave violently as he grew older. Your Honor, the same reasoning applies to our case today. The fact that jurors in Vincent Huff's case chose to sentence him to life without parole, even though they had the option to charge him with manslaughter, and the lesser sentence associated with that charge, is a clear finding of permanent incorrigibility.
Counsel, if there was an error in finding permanent incorrigibility, would this affect the outcome of the case?
If there had been, yes, Your Honor. However, because there was not a defect in the finding of permanent incorrigibility, there was not a problem with the sentencing in this case.
Counsel, there was no stated finding of permanent incorrigibility, correct?
Correct.
But you still believe that despite his age and, as in Johnson v. Texas stated, lack of maturity and undeveloped a sense of responsibility, he should still be given life without parole?
Yes, Your Honor, because Johnson v. Texas rules against Johnson. It rules in favor of the idea that, yes, youth does affect a person's being. However, when it leans into murder and homicide-based crimes, there is an incredible difference between youth and violence. Your Honor, it is clear that Vincent Huff not only received a proportionate punishment for his crime, but it is also clear that he, as many others have and will continue to, have abused Montgomery's retroactive effect in order to escape the consequences of his actions. He was violent enough to commit the crime of an adult, so he will and must serve his punishment, regardless of the fact that he is trying to paint himself as a naive youth who made a mistake. Your Honor, I pray that you uphold the ruling of the lower court and allow for Vincent Huff's case to set a precedent that narrows Montgomery's retroactive effect back to Miller's intended purpose. And if there are no further questions, Your Honor, I pass the podium to my co-counsel.
Thank you. You may proceed.
Good afternoon, Honorable Chief Justice and Honorable Associate Justice. May it please the Court, my name is Elena Prager, and I'll be going over Issue 2 of the case before us today, which is whether or not the trial erred by admitting statements made when Huff was in custody because the Court did not need to take Huff's age into consideration when determining if his Miranda rights were upheld. At the time of Huff's questioning, he could not be considered in custody according to the requirements set forth by Thompson v. Keohane, 1995. These requirements set by the Thompson Court are the ultimate in-custody test for Miranda purposes, where two discrete inquiries are essential for the determination. Firstly, what were the circumstances surrounding the interrogation? And secondly, given those circumstances, would a reasonable person have felt he or she was at liberty to end the interrogation and leave? The Court must apply an objective test to resolve the ultimate inquiry. Was there a formal arrest or restraint on their freedom of movement of the degree associated with the formal arrest? These requirements are vital because they illustrate the contrast between a custodial interrogation and a non-custodial interrogation. The Court of Thompson defines a custodial interrogation as questioning indicated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of movement in any significant way. In Huff v. State, Huff was not in a custodial interrogation. He was questioned at a gas station, where he had the presence of Mia Redding with him at all times, and a walk for several miles, where he was no longer being overtaken by the adrenaline of the incident, all before questioning had even begun. Additionally, in Stansbury v. California, 1994, it establishes that the use of Miranda warnings are only necessary in the admissibility of statements made in the case of a custodial interrogation.
Counsel, would a pat-down and a questioning following that pat-down when the officers found the knife permit a custodial interrogation?
No, Your Honor, because a pat-down does not restrict Huff's movement in any significant way. An officer's obligation to administer Miranda warnings only where there has been a restriction on a person's freedom as to render in custody rights that are appointed to the individual prior to custodial interrogation are set by the case of Miranda v. Arizona, 1966, as procedural safeguards that must be set to protect the privilege and unless other fully effective means are adopted to notify the person of his rights of silence and to ensure that the exercise of his rights will be carefully honored, the following requirements must be met. He must be warned prior to any questioning that he has the right to remain silent, anything he says can and will be used against him in the court of law, and that he has the right to a presence of an attorney, and if he cannot afford one will be appointed to him after any questioning, prior to any questioning. The Miranda Court also echoes under the Fifth Amendment, as no person shall be compelled in any criminal case to be witnessed against himself. The Miranda Court also sets the parameters of what factors are not to be considered when deciding if an individual's Miranda rights were properly issued prior to custodial interrogation. Assessments of knowledge of the defendant possessed based on information as to his age, education, intelligence, or prior contact with authorities can never be more than speculation. A warning is a clear-cut fact. Along with providing the circumstances in which an individual is most unlikely to be subjected to the compelling factors of what custodial interrogation, as in his own home, he may be confident or indigent. He is more keenly aware of his rights and more reluctant to tell of his indiscretions or criminal behavior within the walls of his home. Moreover, his family and friends are nearby, their presence lending more moral support. As stated before, Huff had this moral support from Mia Redding. They were together at all times and walked for several miles before the questioning had begun. Finally, in the case of Burke v. McCarty, 1984, it sets forth that a police officer's unspoken intention of detainment has no effect on the actual custodial implications of a questioning until the individual being questioned meets Miranda definition of in custody. A policeman's unarticulated plan has no bearing on the question as to whether a suspect was in custody at a particular time, and the only relevant inquiry is how a reasonable man in the suspect's position would have understood his situation. At the time that Huffman made the statement, "No, I had already gotten rid of it," he was not in custody, meaning he did not have to be read his Miranda rights. In addition to the fact that Huff was not subjected to a custodial interrogation, his original claim that his age hindered him from understanding his rights given by Miranda is irrelevant.
Counsel, why should his age not be considered a mitigating factor in today's case?
Because we believe that Miranda rights must be generally applicable in regards to all, regardless of individual circumstances.
Thank you, Counsel.
In accordance with these facts, it is clear that the minutes of Huff's statements meets the requirements set forth by previous precedent, as well as the Fifth Amendment. If you rule in favor of the state side today,
Counsel, before you go, you mentioned that Miranda rights must be applicable to everyone no matter what their circumstances are, correct?
Yes, Your Honor.
Miranda rights were created to give more protection to victims or potential criminals. However, in this case, it takes protection away from Huff. So why should the more rigid interpretation be applied in this case?
Because we as a state are setting the precedent that Miranda rights must remain generally applicable because the consideration that individual details would have on the detainment of the individual is not a burden that we can ask of police officers to uphold. The trial court did not err by admitting statements when Huff was in custody because the court did not need to take Huff's age into consideration when determining if his Miranda rights were upheld. And we pray that the court uphold the previous ruling of this case.
Thank you. Helen, are you ready?
Yes, Your Honor.
You may proceed.
Our opposing counsel has stated that the Texas Penal Code and the amendments to the Constitution were not part of the case material. However, we oppose that and declare that as invalid, as Texas law and United States law are required to sentence Vincent Huff to murder and sentence him to the crimes at which he committed. And if we cannot use these, we cannot charge him with a crime. Our opposing counsel also mentioned that whenever the police officer had asked Vincent Huff about the knife, that was a discovery question. However, we oppose that as a discovery question would have to be a question asked prior to the frisk, which would have asked Mr. Huff if there was any weapons on him or anything that could hurt him, which that would be discovered. Sorry, that would be considered a discovery question, not is this the knife that you did it with. That's all I have.
Thank you, counsel. We will retire and make our decision.
All rise. You may be seated. Yeah, I got you. It's so hard for you to read. Yeah, it is. Also, like, you can see. I can just give you a script. I ran out of time. I had to scan out my work. We'll try it. We'll try it, definitely. All rise.
The court affirms Issue 1 and reverses Issue 2, in part the state's judgment, and remands the case to the lower court to correct Issue 2. Case dismissed.